John, are you able to turn your camera off? That's it. Super. Okay, we are recording now, so over to you, Rosie.
Okay, thank you. Well, good evening, everybody. I'm Rosie Pearson, Chairman of the Community Planning Alliance. We're really pleased that Naomi and Hugh offered to do this talk for us on the Levelling Up and Regeneration Bill. I can't stop thinking of it as LURB actually, which is what Simon Ricketts called it on Twitter. So Naomi Luhde-Thompson is Director of Rights Community Action. She runs training programs for communities. She's a senior lecturer at Oxford Brookes University, teaching sustainable futures. And she's led many climate and planning campaigns. Hugh Ellis is a very experienced planning campaigner and expert planner, and I sometimes think if Hugh doesn't know it, it's not worth knowing. He has extensive experience of local government training, and he's a director of the TCPA, the Town and Country Planning Association. So without further ado, I'm going to hand over to you two. I actually don't know who's going to speak first. I'm assuming you've agreed that. And yeah, we want to hear all about what's proposed, particularly what affects local democracy and our right to be heard. And what it means for environmental protection. So thank you.
Well, thanks very much, Rosie, and to Mart as well for allowing us to speak to you this evening. So what I'd really like to do is Hugh and I are going to say a few words, highlight a few things in the bill, maybe go through some of the provisions that you may be particularly concerned about as people getting involved in local planning. And then we'd just like to take questions. And as I say, Hugh will take the questions if we want to do some verbally, and I will take the questions through the chat box. Can you not hear me? I feel like I'm going to have to talk to the laptop. Okay, well, I'll let Hugh do more of the talking then if I'm very, very quiet. I don't know why I'm quiet. Normally I'm very loud. I mean, Hugh would say that I've got a
you're actually
voice.
You're fine. Just that's a lot better. If you could just keep like that, that's excellent. Thank you.
But there.
Yeah.
Okay, slightly awkward position. So the Levelling Up and Regeneration Bill. So I don't know how many people have managed to get through the 338 pages of detailed provisions and complicated changes. But we just wanted to highlight a few of the things that we think are really important because the second reading of the bill will take place on the 8th of June. So that's obviously not too far away. And Marge, I don't know if you're going to speak a bit later about organising maybe attending the second reading debate in Parliament. It's always a good idea to keep an eye on what your MPs are saying in relation to this bill, particularly if you've asked them to speak or raise any issues. But I think the four things that we're going to talk about today are democracy, the way that's affected by the bill. There's various centralising measures in the bill that reduce democracy. We'd also like to talk about the purpose of planning, the fact that it's actually absent in the bill at the moment is something that I think is really important to be called on or called for. And then we'd like to talk about the fact there's several new plans at local levels, so that makes the picture much more confusing. And also the right to be heard and how that applies across the board. And the environmental outcome reports. I mean, that's something that I'm particularly interested in because I did a little comparison today in between what we have at the moment and what the government is proposing, and they look quite different. But Hugh, I'm just going to hand over to you for 5 minutes just to give your initial thoughts on when you first read the bill, what jumped out at you in terms of what it means for planning.
Thanks, Naomi, and I'm relying on you this evening to cut me short when I stray into big areas of boredom, which if everyone's heard me speak before, you'll know I'm completely capable of. So just some quick headlines here. Look, this is the next 24 months with the rewrite of this planning law and the rewrite of the NPPF, a really critically important time for all of you who campaign on planning. So we're going to change national policy and we're going to have a new framework for planning. The other big piece of context is, you know, actually the planning white paper and the worst excesses of that planning white paper were defeated, and they were defeated because government took notice of, I guess, of your concerns. So don't walk away thinking that this is pointless. It isn't. You know, change is possible. But what's happened really is that the worst excesses of the white paper aren't here. But what is here is kind of a bit of a car crash of measures. And it's really hard to read because this is amendments on amendments on amendments. So it's really difficult to describe. Parliamentarians find it very difficult to understand. So it's been done in quite a complicated way, which doesn't help planning being pretty complicated already. But if it's OK, I'll just talk a bit about the detail of the democracy point, and then maybe we could come back now and later to what we might do about some of these things. So if you're interested, the sort of key clauses of this bill are 82 to 84 and Schedule 7, which effectively rewrites the English planning system, not to the same radical extent as the white paper implied, but it is still quite a significant rewrite. Why is it a rewrite? Because the shape of the local plan has changed. It now means something different. The status of the local plan has changed, and the government has introduced some pretty powerful new powers for the Secretary of State to determine policies which local plans used to determine. So when we talk about the issue of the shift of power, the major headline for the democracy point is a continuing shift of power from local to centre. Things that were determined locally will now be determined by the Secretary of State. Whether that's what they intended to do, I don't know, but it's certainly the effect of the bill. Why? Well, let's just look very quickly at what a new local plan will be. I mean, depending on where you are in England and what sort of authority you have, and I'll heavily summarise, the average local policy framework in a local plan consists of a local plan and a proposals map and a neighbourhood plan if you've got one. What you're going to get now is the introduction of two new quite powerful things which are voluntary. So the new local plan consists of a strategic spatial strategy, which is a voluntary document that local authorities will plan together for if they want to. And that will be the sort of document where Greenbelt is determined. So that's a strategic spatial strategy. That sits as at the top of the local plan. And then underneath that, you'll have a local plan, which looks not much like they look at the moment, because the bulk of the development management policy, what is development management policy? The stuff that allows you to say yes or no to things. So it's the bulk of a local plan. That's going to be stripped out, and key parts of it will be centralised. And I'll come back to that. In other words, Secretary of State will issue them nationally. So local plans will be very focused on simply allocating sites and the policy to go with them. So that's the second element. And the third element is the supplementary plan. And that's where the new emphasis on design codes will go. So they're kind of taking away development management policy in the local plan and putting it into the supplementary plan. And if you've all got migraines by now, I mean, I don't say that lightly because I suffer from them, then you're in the right place, because if this is a simplification, then I'm a white rabbit. So what you end up with is a framework where you have this collection of documents. But here's the thing. At the moment, you have a right to be heard in the local plan if you object. And that means you've got entry to the decision-making arena. But the new legislation says that for strategic spatial strategies, you positively don't have a right to be heard. It actually says there is no right to be heard. And then for the supplementary plan, which contains the design code, there isn't a right to be heard either, which means that essentially an inspector who has to examine it can, if they want to, invite you to be at that. So in practice, what this means is that while your right to be heard in this local plan, this slimmed down document remains, quite a lot of the important content strategically and in terms of design codes is now in plans for which you don't have access. And that cannot be. That has to change, because all of those plans now have the same legal status. They are all development plan documents. So the strategic plan, the supplementary plan, the local plan, all have the same legal status. But you don't have a right to be heard in two of them. Now, I think officials probably think that that's a minor issue. But for me, if you're arguing about Greenbelt or arguing about net zero in a design code, you've got to have access to the decision-making arena. And so we need to make sure that those clauses are amended so there's a right to be heard for all documents that count as development plan documents. Otherwise, you're losing out of that. So the positive thing in these clauses, just quickly, is that they're strengthening the status of the local plan. I don't think it's very seismic, but they are attempting to strengthen the status to reduce speculation. That's a positive thing. Local plans are hard fought, and once they're in place, they have to mean something. Otherwise, what's the point? So that is a positive. But then the final part of this that's not so positive is that the Secretary of State is going to create something called National Development Management Policy, which will be published in a sort of form of the NPPF. And that will include things like Greenbelt, and it will include things like heritage. But the way the law is drafted at the moment, there is no limit to what the Secretary of State can't put in that national policy. There is no proper public participation process around it. There is no parliamentary scrutiny of that document. And crucially, National Development Management Policy is being given more status in decision making than your local plan. So where there's a conflict, the conflict is resolved in favour of the Secretary of State's policy. That is a massive power grab. And it also means that, quite without exaggeration, a new Secretary of State, because I'm sure Michael Gove doesn't want to do this, but a new Secretary of State in the future can essentially outflank all the work that's been done locally overnight without any kind of fulsome public consultation on issues like Greenbelt. And so that's another issue of the bill that just cannot stand. So there is a very significant issue at stake about rights to be heard. And there is no doubt in my mind, after spending many years staring at it, that the bill is a step back from the sort of rights we need. I would only say, Naomi, to finish on the democracy point, that neither is there a third-party right of appeal. There's been no extension or attempt to reflect the need to rebalance the balance of power in planning. And I think that's a great shame, because there's a massive public trust problem in planning, and the government needed to do something about that. And instead of doing something about it, it's essentially set us back. So I don't know if it's worth pausing there, because I know that's incredibly, in some sense, it's kind of buried in the clauses, but there is something very important at stake that's worth fighting for, I think, in terms of people's rights in the process.
A couple of
Do you have, sorry, Mars, do you want to come in with a couple of questions?
I think a couple of people have put questions in the chat, so let's just take a look at some of those. Alistair Scott has asked, how does what Hugh says play out with the Aarhus Convention, which gives the public right to be consulted and involved on matters that affect them? Don't know if you guys want to pick up on that one.
Yeah, I mean, I think, Naomi, you don't know how much you want to say about the fact that RCA is reaching out for some legal support, isn't it?
Yeah, I've just popped that into the chat box, that we're commissioning some legal advice on the right to fair hearing, and to basically map across the bill where we're getting changes and where basically rights are being reduced, and where new plans or policies are being introduced without the attendant right to be consulted on those. So we'll share that as soon as we
Great to hear. Great to hear. Simon actually asks, so what is the local planning authority and community groups? What do they have a right to be consulted on, you know, and to input with this? Are they just left with design? Just before you answer that, can I ask Nick and Richard to turn your cameras off, please? So that only the speakers have their cameras on. And can you put your questions in the chat as well? So Naomi, over to you and Hugh.
So I think it's in terms of what you're left with, there are two big things that have happened. One, obviously a massive expansion of permitted development, which has taken power away from communities on all sorts of the conversion of all sorts of development. Class E changes have also added to that problem. So there's been a shift of power to the centre there, because those are the framework for those are determined centrally. What the government is after is speed. It wants everyone to have a local plan. That's a great aspiration, inside with a 30-month time frame, and it sees the job as slimming down what's required in law in a local plan to a bare minimum. And that bare minimum is basically setting out the strategic priorities for growth in an area. Now, it doesn't mean to say that local plans can't do more, because in law they can, but that's the aspiration they've got. And it is curious, because if you have a local authority that's reasonably well resourced and you're a reasonably well resourced community, the local authority might say, let's have a supplementary plan and deliver on net zero. And that's an opportunity. But of course, that circumstance doesn't exist for most places. But what it really means, though, is that you've got this mismatch between a framework local plan and some other key delivery plans which you do not have a right to be represented in. And the origins of that actually are interesting, because they do come partly from the speed issue, Project Speed in Treasury, but they also come out of local government that was saying, well, we don't have the capacity to do this stuff in terms of consultation, and that worries me a lot, because I know they're under a lot of pressure, but that is not a reason not to have a properly participative process.
Yeah, it's very worrying, isn't it? And Emily is saying she gathers that there are also new powers, government powers, on deciding infrastructure, including solar, wind, nuclear. What difference will they make, those powers?
So this bill is what parliamentarians call a Henry VIII bill, which is to say that there's a lot of clauses in it that don't tell you precisely what they're going to do, but they take power to the Secretary of State to do it in secondary legislation. So there's a lot of those, and one of those is about street votes, which I'm happy to talk about, although I do think it's a red herring for democracy. But there's a missing part of this bill that was meant to be in it, but disappeared, and that was all the stuff on national infrastructure. So that's not been published in this bill, but it is apparently going to be inserted into the bill after second reading at committee stage. And I suspect we'll see more of that, which is very, very difficult for us, because it's become the tendency with bills that you basically don't see the whole picture until the bill's actually trundling through Parliament, which raises a few issues. So what we expect on that is condensing of timescales for major infrastructure projects. But I have to confess that I don't know the detail of how good or how bad that will be, except that there's been a lot of pressure to shorten the timescales on the process. They're already pretty short, and people's opportunities in major infrastructure, Naomi, they're not great by any manner of means.
Well, our experience is that it's obviously really, it's so time consuming, because the to and fro, the written representations, the restriction, and the open floor hearing is literally just a kind of soapbox moment for 10 minutes, and you obviously need issue specific hearings to get into stuff in detail. And my experience is that when you're in those issue specific hearings, if you don't have the evidence, they don't wait for you to get it before they make the decision, or they don't wait for it to be produced. So I would say that some of those decisions are going ahead in a pretty poor process, effectively.
Predetermined then. So
well, I mean, the whole system was set up to approve infrastructure. So that's obviously what it's trying to do all the time, is approve infrastructure. I think the big worrying thing about those sorts of developments is if all of the environmental impact assessment regulation is changed because of the introduction of environmental outcome reports, plus there are changes to the environmental assessment of plans and programmes, which is obviously the SCA directive, and if that changes the way, for example, national policy statements have got an environmental assessment, or local plans have an environmental assessment, or SDS have an environmental assessment, then we might see much less consultation in those. So while there is a commitment in the bill to non-regressive, so it doesn't go back from European, what we've inherited from European legislation, if you actually look at the detail, down buried in the schedules, as I was looking today, you actually find that in regulation they can just change anything once it's through.
Once it's
through, there's no kind of guarantees there as to what will be retained, and they actually change the sort of what's considered to be an environmental assessment is changed from something that's outcome focused about real environmental issues to something which is about, well, have you managed to mitigate it? So it's not about the environment in and of itself, it's more about how you've mitigated your impact. So
how have you played the system then? How have you played the system? Okay. Now I know
Hugh just wants to come in quickly, Marge.
Go on.
Raising your finger.
I'm just saying that I could just to try and deal with a few more of those questions. The point on the Oxford CAM ARC is, yes, I mean, it's exactly that sort of association of councils that could put a strategic plan together, and probably in a way should, but only if it's robustly tested. And that means that clause about ruling out a right to be heard in those strategic plans has to go. And I think that is a top priority in talking to MPs There's a couple of resources on the TCPA website that sets this out in a bit more helpfully, perhaps. But in terms of what the rest of the bills, I mean, I haven't talked about that because it's very difficult working in Westminster, because it turns out that sometimes people actually don't tell you the truth about bills. It's an extraordinary idea. But the levelling up bill really isn't a levelling up bill. It's actually a planning and devolution bill. The clauses at the front end of it about levelling up are incredibly brief and incredibly weak. They essentially say the Secretary of State can determine what missions the levelling up agenda has and has to report to Parliament on whether or not it's delivering on those missions. By the way, it can drop any of the missions it finds inconvenient. So actually, this is really devolution and planning. And the bill really sinks and swims on the public trust issue. Don't be diverted about the fact that there's some kind of amazing levelling up agenda in it, because the remarkable thing, there isn't. You know, it's just not there. There isn't provision for things like local food or community housing or what you might think would be some positive outcomes. It's very curious, really.
Yeah, and I think in relation to that, Hugh, as well, I would say that, you know, while the Levelling Up white paper spoke a lot about well-being, there's nothing about the fact that, well, we all have a right to a healthy environment and a right to well-being wherever we may be in England, and that is not reflected in the bill at all. That kind of concept isn't, and set of values is not reflected.
Yeah. Okay, so I know you've mentioned, Naomi, that you're going to you're seeking legal advice. We have got a couple of questions from Matt all about what we're going to collectively do. Are we going to come to that at the end when we talk about going to the going down to the second reading, or do we want to come back to that at another point?
I think we could talk about it in when we've gone through all the sort of maybe the technical questions, Marge, like the kind of next steps.
Yeah, okay. Yeah, we've got one or two other questions, but can I just ask, do you want to move on to the next point, and then we can, because have you got anything else that you want to share with us before we, or shall we continue going through the questions?
I think go through the technical questions, because that's the heart of the bill, those clauses and that schedule. And then I think, Naomi, we can talk more positively about what we're going to do and what the sort of alternate clauses are that might be put down.
Okay, so let's just take a look at some others of these. Catherine has asked, are there any indications of what will be in the National Development Management Policy?
No, that would be far too easy if they'd done that. No, that's what's funny about this. There isn't, and they say there's a constant issue of trust. And I've had to say to officials, you cannot blame people for not trusting you about this stuff, because you know the planning reform process over 10 years has not gone well for communities. The idea is that they will publish, and this relates to the NPPF, Marge. They're going to publish a sort of a statement which will include how they intend to rewrite the National Planning Policy Framework and the broad content of what they will consider to be national development management policies. My advice to everyone is to be deeply cynical about that, because it's the law that determines what power the Secretary of State has for all time. Whether or not somebody wants to tell you that they won't use that power to do anything bad, I mean, I'm sorry, but we didn't all fall off a Christmas tree. What we need is either the law to be clear that the Secretary of State has a limit to their power, or at the very least that there's some parliamentary scrutiny and community participation. For me, it's a top priority to persuade MPs that it is the local plan that must have primacy, that you can't start suddenly introducing national documents that have no participation, that have more legal status in decision making than the local plan. It just turns democracy completely on its head. So it's an important point, Marge, I think, to try and get that sorted out.
Yeah, and I think this reduction in our rights is just permeating through so many other areas of government policy as well. So we do need to be right on top of this. I know that Nick asked a question about the Oxcam art consultation, get my teeth in, and Caroline's also asked a question: if examinations are still required but without the right for the public to participate, does that mean developers and promoters also have no right to be heard? It will all come down to the inspector then. So, you know, in terms of the consultation, yeah.
It's basically down to the inspector. Essentially. Oh, sorry, Hugh, you go for it.
Yeah, I think that's right. I mean, the way I had the opportunity to talk to the planning minister about this, which was a good, actually a very fruitful exchange, and he's, you know, I think he's in listening mode, as they say. But the point is that government keeps emphasising digital. Okay, so whenever you challenge them about community rights and planning, they say, well, there'll be all these new digital opportunities to decide to be involved. But the example I gave was it's a bit like an MP being digitally involved in a bill, but then locked out of the House of Commons. So you'll all be fully informed about what's happening, but you're not allowed to get into the decision-making arena. And just to be really clear about how that works now, given these other questions, I tried to outline that there were these three elements of the local plan. Well, there's more, but there's at least three. There's a strategic plan, the local plan, and the supplementary plan. Only the local plan is required by law, and that stripped down plan has a right to be heard, and that is not at the inspector's discretion. If you object to a local plan and sustain that objection, you must be heard in person at an examination. That right was hard fought for 50 years, and fighting to retain it has been an immense struggle over the last 10 years. The other two plans, the position is this: on the strategic plan, the law in this bill says that you have no right to be heard. It positively excludes it. On the supplementary plan, it says the inspector has discretion about whether or not to have an examination in public at all. So it can be heard by written reps, and has total discretion about who is heard, whether that's developers or the public. I hope that's a bit clearer, because it is
complicated. So
yeah.
So for the Oxcam ARC, for example, the consultation that Nick is concerned that it might be ditched in total, how would it affect that consultation?
So I wish I could give a clean answer to that, I really do, but it just depends. Now the government sort of walked away from that as a strategic policy. What presumably could happen under the new legislation is that the various local authorities, assuming they're all still agreeing with each other, could jointly create a strategic spatial strategy for the whole of the ARC. Let's just take that as an example. I mean, I'm not sure that's likely. It depends on whether they all agree. But if they were to do that, they could set out quite significant policy about how the ARC is going to be developed through a process for which there was no right to be heard.
Yeah.
And once that plan is in place, okay, that counts as the development plan for decision making, with equal weight to the local plan. And when you write a local plan, you have to have regard to the spatial plan. So you can see, I hope, that it's vitally important that people are involved in setting the strategic policy.
Yeah.
And there's always been a conceit that people are not capable of doing strategic policy. Well, I'm not going to swear this evening, but they are, is all I would say. And they have to have an opportunity, if they want, to be involved in that process.
Agree.
Just to add to that, Mart, as well, I mean, you also have to think about the fact that the national development management policies are getting so much more status. And if there is a conflict between the national development policies, and the local plan, it's national trumps.
Yeah.
Every time.
So,
and the Secretary of State could literally wake up one morning, have a cup of tea, decides he wants to designate a different set of policies and do that. Because he also decides if there is any consultation. It's in quotes, if any consultation happens. So you've got this huge amount of that's why we talk about the bill. It's a centralising bill, because all of this power is being hoovered up essentially, because it takes so much influence away from what actually the local plan at the moment has. Although we think that the NPPF is trumping the local plan quite a lot at the moment, it's going to be even worse.
Right. And I think one other point that's linked is the Human Rights Act, which currently Article 6 gives us the right to be heard under planning law, and obviously that's being rehashed. So do we know whether that right to be heard under planning law is going to go from the Human Rights Act as well?
The Bill of Rights, which Dominic Raab is introducing, has been through consultation, Naomi, hasn't it? It was very controversial with the legal profession, but it's not been, as far as I'm aware this evening, it's not been published. So we don't know what that will do, but there is no doubt what the agenda is behind that bill, in terms of moving away from some commitments around human rights. So that makes this more difficult, I think, and more important. It's even more important that these rights in planning are sustained in the planning legislation, because we might not be able to back them up elsewhere. No. And Michael actually asks, are they retaining the equality impact assessment in the documentation as well? Do we know? Environmental impact. Sorry, go on. You go.
Equality.
I was going to say it's different legislation, and I have not seen that they're changing that in this. But obviously they're changing environmental impact assessment and SCA. So
yeah. Okay. Still got quite a lot of questions coming in, so which is really good. So let's just take a look at some of these. Will the precautionary principle as stated by Article 191 of TFEU not be able to amend the Henry VIII provisions? And I'm sorry, I don't know what TFEU is. Perhaps
the European Union.
Right.
The European Union Treaty, so Article 191 is the precautionary principle.
Right.
Sorry, what was the question? I think I've lost.
Will it be able to amend the Henry VIII provisions, basically?
No.
Okay.
So, because we're not part of the EU anymore, so we have to. So basically, when the Secretary of State gets Henry VIII provisions, what he basically does is gives himself the power to make, through regulations, various different frameworks to govern different processes. So he basically says, I'll decide how to do that later. So you don't know the exact shape of what he's deciding to do later. You kind of have a general outline that he's given himself powers to write new regulations, for example, on the environmental outcomes report. And that means going through secondary legislation. That means that there isn't the same scrutiny as you have, for example, as on this bill, where you have a public bill committee, which sits down and goes through the bill line by line, which has various debates on the floor of the House of Commons, which has opportunities for MPs to table amendments, and has to go through the House of Lords. So secondary legislation, statutory instruments don't go through the same thing. And that power to kind of make those laws, there is no requirement to consult on those. And Rights Community Action took that case around permitted development rights and the changes that were made there without consultation. Basically, ministers have a lot of discretion under the UK law or under the way the country operates. So they're not a good idea. Effectively, it's more power being centralised to a single person rather than more accountability or checks and balances. And if you see it on the face of primary legislation, then you have lots of checks and balances because of the way that law is made.
And the lack of scrutiny is horrendous, really, isn't it? So Nick is asking, is there anything on social housing in the bill?
You're on mute, Hugh, if you're answering that question.
Old man can't have Zoom properly. Yeah. There isn't anything positive in the sense of a duty that focuses our minds on specific provision of social housing, but a lot of that debate's been wrapped up in the new national infrastructure levy, where the government have made a commitment to say that the new levy won't lead to any less social housing. But there's some good resources on Shelter's website with an analysis of that, if that's useful. I haven't got the link, but they talk quite a lot about how that will work. But just so again, it's difficult to get into this because this is just a whole other hour. But so So at the moment we have Section 106 and we have the Community Infrastructure Levy. Everyone was saying those are horribly complicated. So the government said, well, we'll replace them with a National Infrastructure Levy. But the National Infrastructure Levy now is set by a national formula, but it's locally determined at what rate it's set and it's locally collected. So I'm struggling to see how that is a National Infrastructure Levy. The biggest problem with it is that the same challenge remains with it. It's just a national SIL system, really. But the same challenge is that you get a lot out of it if you're in Kensington and Chelsea, and frankly, you get nothing at all out of it if you're in Gateshead, because development values determine how much resources you get. And at the same time, the challenge we've got is that the requirement for net gain, which is essentially an offsetting scheme, which I have a lot of worries about from a community point of view, but the net gain idea, which is good in principle, but I worry about in practice, also takes money out of the same pot. And no one's done the work about whether there'll be enough money in the pot to do both net gain and social housing through that resource. So sorry to get into the financial part of it, but that is a whole other part of the bill we haven't spoken of.
It's all, yes, it's all very complex, isn't it? So we got quite a number of other questions here. How will neighbourhood plans work? Many of them have development management type policies. Will they be obsolete too?
So the neighbourhood plans get strengthened a lot because they are already part of the development plan, so they benefit from that strengthening. So let's start with the positive. The reality is that whenever the government issues a new version of the National Development Management Policy, the new policy issued centrally will have more weight than local plan policy. So it's not that it trumps the neighbourhood plan on its own, it trumps all development plans when it's issued. So that's why we're so worried about it, because unless you're clear about what the limits to that power are, you end up with a system that can be very easily disrupted. And I think what people should focus on is that what we're after here is really, good neighbourhood planning, is reflecting communities' desire to do things like from food to natural flood defence to community housing. It's a positive agenda, but there is no point people engaging in that process if the plans themselves are easy to overturn. What's the point? Is that, so I think the answer to that question is that, well, that's why we're worried about these clauses.
Yeah, no, and I agree. We're right to be worried. We have had a couple of playing devil's advocate. Should national policy trump local policy and local plans and what have you? I think it would be good to just talk through that, Naomi, because there's not a consultation at a national level on some of these policies, is there?
Yeah, I would see this as two issues. One, the difference in between participating in a consultation where you essentially put something into a black box and you've got no idea what's coming out the other end. It's written, isn't it? It's not a debate or an engagement in person. I mean, it's really, really important that the local plan examination, it's a right to be heard in person. So, lots of you will have experience of you put in a consultation response, it kind of drops into that post box. You've got no idea what happens to it, and you've got no idea whether it's going to mean something or not. To participate in person in examination, to make those arguments, to sit across from the people who are arguing for whatever policy, to have those people in the room, that's a very different way of crafting and formulating a policy and bringing evidence in. So I'd argue that there's a difference in between participating in an examination and a consultation. If the national planning policy framework becomes this national development plan policy, well, it's virtually a plan. So why isn't it tested through examination, for example? Why isn't it subject to the same process? I mean, you've got a policy in local plans that don't have as much importance in the system, and yet they're going through a more rigorous process than national policy that's being created by civil servants as a consultation. He just has to respond to that consultation, but effectively he's got the power to do whatever he wants in that policy. It's a quite a different kind of balance of power in practice. So you have to think about why are different plans and more powerful plans, why do they have less rigorous processes and procedural rights attached to them than other plans? why doesn't the same test apply to all of these policies? Or why isn't it that the most important policy in place for a decision has the most rigorous testing? I mean, if you think about it logically, rather than, you know, responding to what the government's doing, you know, so I think that's the questions that I would ask of the bill when you're thinking about, well, what would be the system that would guarantee that I have my voice heard and that it is taken in account and that there is some form of accountability. If the Secretary of State does not listen to a consultation response, you know, there are ways for the Secretary of State just to say, well, I've considered that, but I'm going to do something different. I mean, that is effectively what's going on. So how would you make sure that the Secretary of State would have to take into account your representation? I mean, that's the key thing. The other thing is obviously you've got national policies and they play a certain role, but local policies are much more specific to the area. You might have different policies, priorities locally. So how do they get balanced with national priorities? And that's another question to kind of ask ourselves, like, where does the balance lie in between what's the national priority, you know, what's common to, or what should be common to all development decisions, and what's specific to an area, what's really important and is a priority here locally, because this is the local context and these are the local needs and these are the local issues that we have to deal with. So I think it's about thinking about it like that and thinking about, well, what do we suggest would be the best way to put together the best policy at the different levels? And if you come from that to then look at, well, where would changes be required?
Yeah. And I think that's understood. My concern is that the planning inspectors' examination are not always, they don't always seem to have the right level of balance. So if we consider the current, you know, requirement for sustainable development, yet planning inspectors are approving developments on irreplaceable habitat. They're approving developments without any sustainable transport. You know, so that there's a concern there that although you may have a right to be heard at some of these examinations in public, the value of your contributions as a local person is maybe not considered to be as important as those of the developers and the councils who and money just seems to trump everything, doesn't it, at the moment? So another question here is, do Naomi and Hugh think that the ideological intention is for planning to stop being a process of collective and local choice about the future and become an autocratic political product dictated by central government? So what's your thoughts about the overall intention? You're on mute, Hugh, sorry.
Sorry about that. I'm tempted just to say yes to a question like that. I think the challenge that we've got is there's certainly, I mean, you'll have all seen now that there is a national design code guidance, and that's not half bad actually, but it is national design code guidance which people should be following in developing their new design codes into this process of the supplementary plan. But there is a sense that government is telling you what beauty means, which I find a bit troubling. And I think in my long experience of engaging in planning reform, there's absolutely no doubt that there's a current enthusiasm to get planning out the way. That's sort of fallen off the rails a bit. But what's left over is that at absolute heart, they don't trust communities. It's really interesting. There isn't a trust in communities that they'll make the right decisions. My feeling is that communities are best placed to make those decisions. Sometimes they'll make mistakes and sometimes they often do brilliant things. But I think that this centralising tendency is very difficult to counter. So what comes out at the end of this, I think, is sort of a kind of chaos. That's the trouble. And I would say for people trying to understand it, the point you raised, Marge, about you know, inquiries, for people trying to understand the system, we've now got a less effective, more centralised, but incredibly more complex system. And it takes real genius to manage to get to that place. real genius. I mean, it's not a simplification for people, but I think that the point is that it's not just about people's rights, it's about being enabled to use them, and you need the resources to be able to do that. Sorry about the dog in the background. He's particularly annoyed about the centralisation of planning policy.
I think he's desperate for a walk, Hugh.
Oh, he is. That's what he's telling me, is it's 6:15 and we've not gone out yet.
Okay, well, we'll jump through the questions then. How does devolution fit into this? For example, Greater Manchester has places for everyone across 9 boroughs. So we have a regional spatial plan called Places for Everyone. Anything that we need to think about there, where regional mayors or regional groups of authorities come together?
Yeah, I mean, there's quite a lot of stuff. A lot of the planning in England now, you can't talk about an English planning system. Planning in London is completely different from planning in Manchester. You know, London plan legal status is totally different to the Manchester strategic plan. So, you know, it's difficult to describe. But the bill contains, the big measures in the bill are about county deals. So creating the same devolution offer to some degree that some of the big cities have had. And in that, creating powers where there would be new powers for what they call mayoralities, but for new elected mayors. And those powers are pretty extensive, like the London mayor has to set up development corporations, for example, in those areas. So if the issue now is that planning, your planning system depends entirely on whether you live in a 2-tier authority or a metropolitan area or whatever it depends very much on where you are. But as a general rule, the mayors are getting more planning powers, particularly around development corporations, so they can designate them, and that raises that's a whole other meeting about whether development corporations, which can be great, but there are issues about accountability.
Yeah. Caroline's just put an interesting comment in that Hampshire's economy is bigger than Wales, so you know, we do need to think about, you know, what is a region, don't we? And okay, so Richard has asked, is there any TCPA evidence weighing how much of public and parish council inputs to plans is promoting development and land use, and how much is just opposing the local government's assessment, which usually is typically informed by developers? So
well, I kind of half responded to that, and I'll see if I can dig out the link. There's a very popular bit of research in that government debates a lot that comes out of Herefordshire. I actually haven't seen the original document, but what they say it says is that the neighbourhood planning process in Herefordshire ended up designating more homes than the local plan, and they use that as an example of why, if you let people, you know, if you let people plan properly, then or at neighbourhood level, then you end up with you actually end up with a larger number. I don't think, I'm sure that's true for Herefordshire. I haven't seen the detail of it, but I'm not sure it's generally true. And of course, neighbourhood planning is brilliant, but it still needs to act within a framework of standards. It still needs to uphold sustainable development. It still needs to, you know, allocate homes in the right place, doesn't it? It can't be outside of those requirements. So there's a little bit of research there that might be. I'll try and see if I can find it.
That'd be brilliant. Okay, thank you. And
Marge, I was just wondering if we could just quickly run through, because it's 20 past.
Yes, let's do that.
My 20 past 6, sorry, on my clock. And there's a couple, the Better Planning Coalition, which of course Community Planning Alliance are a member of, have got a few proposals for the bill. And I'm just wondering whether you want us to run through those quickly now. Yeah. I can continue answering in the chat, Hugh, and Hugh, if you could just go through what the
yeah, sure. That's code. That's code, Naomi, isn't it? Because you know I've reached a point where I can't speak and read at the same time, which is perfectly true. So the Better Planning Coalition is 27 social and environmental organisations, of which this network is part and the TCPA is part, and it's an unprecedented attempt to cooperate to try and get to improve the planning legislation. And it's defined around 6 asks, well, sort of 6+1, just to raise some of the issues it raises. There's obviously the asks are around, because it's predominantly an environmental sector, there are asks around climate change and there are asks around nature. There's asks around affordable housing and sustainable transport. And we're developing, the coalition is developing amendments around all of those issues. And an example of one of those would be binding the planning legislation to the climate acts more effectively, so the 6th carbon budget binds on planning decisions. I think the one I would pick as a standout issue for this evening, because we're quite short of time, that's really worth supporting, is it's also pushing a new statutory purpose for the planning system in England, founded on the principles of health, well-being and sustainable development, and particularly taking the Welsh idea of the fate of future generations, essentially, and putting well-being of future generations and putting that into law.
The fate of future generations.
Yeah, sorry, I'm getting tired. And that is really worth supporting. And I think if people want something to do, what will be much more effective than in previous rounds of campaigning is that when that briefing is published, which it will be next week for second reading, lots of organisations and individuals can actually ring up their MP and say, we want you to support that purpose for planning amendment. And I think the reason it's significant, some people, is because it sort of redirects the planning system for the first time and makes it more honest. There isn't a proper statutory purpose for the system, and that means that whichever government gets in, they can effectively rewrite its direction overnight. And the statutory purpose around the UN Sustainable Development Goals would give England a development goal for the first time in decades. And I think that's really worth struggling for. So I suppose what we're saying is we can be a lot more helpful, I think, Naomi, than perhaps in the past when people have said, well, it's all awful, but we're not quite sure what to do, because we have got a framework of amendments which we can circulate to you, and people can promote collectively, or they can promote to their MP individually. And that will be published, I'm hoping, next week or the week after.
Yeah.
And yes, that's the CPRE are hosting. So if that coalition at the moment, and they're just in the process, I think, of appointing someone to coordinate it.
Yeah, and thanks for putting in the link to the 6th test, Caroline. So basically, those are the 6 areas in which amendments are going to be promoted, plus the purpose of planning. Because I think one thing that's really apparent from this bill is that there is no agreed purpose for planning, and we really, really need one, because everybody is trying to do different things, and actually having that kind of substantive, on the face of legislation, what is planning for, is going to help everybody, because there's going to be an agreed agenda, it's an agreed set of values, an agreed set of principles. So all of the different planning instruments that we have underneath that will collectively be working towards something. And it's hugely important because, we're running out of time on things like the climate and ecological emergency. And, now is not the time to be, just doing first come, first served, whatever the market wants. This actually has to be much more strategic and purposeful than that.
Okay, well, should we move on, Naomi, to the 8th of June and what the plan is for that day?
Yes, so we don't actually have a plan. It's more of a suggestion to people, should they be interested in participating. So obviously, I presume I'll quickly, so second reading is when the bill is read for a second time on the floor of the House of Commons, and MPs can put forward their name to speak to different parts of the bill. So that, depends on who's interested in it, and there will basically be a public debate. So prior to that second reading, there's obviously going to be briefings going out from obviously the Better Planning Coalition and other organisations saying this is really, really important, you need to talk about this in relation to the bill. We were suggesting that perhaps some members of the Community Planning Alliance, whoever's interested, may want to attend Parliament and the second reading debate on that day, because there's a really good sense of accountability there if you have spoken to your MP or asked them to participate in the debate, and said that you're going to be there for the second reading and that you're going to be watching that debate. And the TCPA, Hugh, I hope this is still correct, are happy to offer a meeting room space for people to gather in before heading over to the House of Parliament, because you've got a very conveniently located office, Carlton House Terrace, so it's just next to Trafalgar Square. So that was the proposal. So obviously as an alliance you can take it or leave it as you wish, but it was just a suggestion or an offer.
Thank you.
Hugh,
That's
I don't know
amazing
if
offer. So what would we need to do if people wanted to do that? Just give you names? Have you got restrictions on numbers or timings, things like that? Sorry, that's my dog now.
So
Hugh, how big's your meeting
I mean,
room?
I would. Well, you know, it's not huge, but you can get sort of 25, 30 people. And it's really just as a place where people can gather before walking over to Parliament. You know, and I'm sure, and that's available, just in terms of people gathering their thoughts. But then it's a straightforward process of making your way through the sort of security process and asking to be in the public gallery for the bill. There is a limit on the numbers in the public gallery, Naomi. I think I can't remember exactly what it is. I would say that's definitely one opportunity. It's worth doing. But the other one is, for me, this issue will be determined, as you all know, because you're experienced campaigners, by conversations with Conservative MPs and raising the issue with them and getting them to raise it in Parliament. And so that's the second part of the non-plan, Naomi, isn't it? Really, that you need to talk to MPs, and a lot of people I think that there isn't an issue now with planning reform, that it's kind of all right and they can sort of relax. But I think actually that they need to know that people are still worried and concerned, and they need to know that the government needs to work harder on these issues if public trust is going to be rebuilt on this issue.
So there are some questions coming through. Do we have to book in to Parliament beforehand or anything like that? No.
No. You just turn up to St Stephen's Gate, which is the bit next to Oliver Cromwell, which is ironic, and then it can take up to, depending on the queue, 45 minutes to get through security, or it can take 4 minutes depending on who wants to go. If you go on the parliamentary website, you can see the process.
Yeah,
Right,
I mean,
well,
just to mention that when you're in that queue, it's and you want to go into the public gallery, you basically say that you've got an interest in the bill. So that's what you say when you're in there.
You don't need ID. Just trying to answer some of the questions. And I think in terms of the issues to raise with your MP, I mean, this is all very new, and I wish we had, in some sense, I wish we had better resources, Naomi. But if you want the detail of the democracy points, that's in that link I sent you that's on the TCPA website to that blog. So that gives you quite a good basis for a briefing with an MP on the democracy issues. It's not intended to cover the whole bill, but it gets to the heart of those clauses, I think, around that. Have you put that in the chat box? I have, yeah.
Right.
And Stuart Andrew is the Housing and Planning MP. He's MP for Pudsey, if anyone's on this call from that patch. And he's quite a nice guy. And
he did fight to protect the Greenbelt in Leeds, which they won their judicial review, and he did fight for that in the court, actually.
So I would also say, and I've literally only got a minute, but just as a thought, I would have thought the Alliance should write to him and seek a meeting with him. You know, I think that could be incredibly influential in terms of the size of the network, just to remind him about why surely you don't want to do this, Minister. You know, surely you want to promote an open system, and I suppose it's code for surely you really don't want to fight with us about this.
I've already requested a meeting with him through Graham Brady, but nothing's come forward yet, so I'll chase that. Okay.
Yeah. I have to run. I'm really sorry.
Yeah,
the dog killed.
No, that's fantastic. I think everybody will agree. That's been a great insight. I think, Rosie, we might want to think about follow-ups to this session, because you know, I'm sure people will want a bit more information on various things that have come out of this. But a great
I'm happy to share the slides, Marge.
Yeah.
So I don't know if that helps. So the slides with the provisions that we were talking about, I'll just email them to you. I mean, I don't know how you share these things, but I can email them through.
I'll share them with the people who were registered for the session, and then I'll also share them on our website as well in some way. So yeah.
Thanks for all the questions. That's really brilliant. It really helps because everybody here's got so much expertise and so much experience of the planning system that it's really helpful to have this debate to understand what the implications of the bill might be. So thank you to that.
No, thank you both. Much appreciated.
Bye.
Bye. Bye for now.
You.
Bye.
Bye. Thank you very much.
Bye. Thank you.